School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 6 Business and Sustainability Unit 14 Consumer Protection Law Part 1.
After completing this unit, you should be able to understand the evolution of consumer protection, identify the consumer authorities under the Act, discuss the powers of the Central Consumer Protection Authority, explain the process of filing of complaints, and appreciate the important provisions of Consumer Protection or E-Commerce Rules 2020. Introduction. The economic growth of a country depends on consumers, and it is vital that they trust the products and services providers. In 1930, when the United States of America was facing Great Recession, the then President Herbert Hoover, while addressing the Congress, had remarked, and I quote, "Economic depression cannot be cured by legislative action or executive pronouncement. Economic wounds must be healed by the action of the cells of the economic body, the producers and the consumers themselves." Unquote. In a free economy, the substandard products or services has to be sacrificed for producers or providers of quality goods and services which will have an overall impact on the economy. Consumer satisfaction and taking care of consumers' interest is in the long-term interest of businesses, as a happy customer would not only prefer purchasing the quality products or services for himself repeatedly, but would also encourage prospective customers by giving good feedback and thus help in increasing the customer base of business. Secondly, self-regulation in producing quality products may protect the producers from government intervention or action which can impair and tarnish the goodwill of the business firms. Consumer protection and empowerment attains prime importance since all human beings are consumers of goods and services, and even businessmen who partake in selling of other goods and services are ultimately consumers of goods and services produced by other sellers or service providers. Business and consumer protection go hand in hand, and consumer protection is as important for businessmen as for others because of long-term interest of business in consumer satisfaction. The evolution of consumer protection. The concept of consumer protection is not new. We find reference of the law and policies for consumer protection in ancient Indian texts, including Kautilya's Arthashastra. The modern consumer movement worldwide initiated when US President John F. Kennedy on 15th March 1952 referred to 4 consumer rights in his famous speech in the US Congress. From the next year, 15th March was celebrated as World Consumer Rights Day on the initiative of Consumer International, an international consumer association formerly known as Consumer Union. It was a result of worldwide consumer movement that in the year 1985, the United Nations adopted the Consumer Protection Guidelines, and one of the mandates of these guidelines for the signatory countries was to pass consumer protection legislations in their respective countries. India, being a signatory to the guidelines, became the forerunner to pass the Consumer Protection Act in 1986, the very next year of adoption of the guidelines in 1985. In fact, India is perhaps the only country where a dedicated machinery for redressal of consumer complaints has been set up. Before the passing of the Consumer Protection Act 1986, there were various other existing legislations to protect consumer interests, including Indian Contract Act, the Sale of Goods Act, the Standards of Weight and Measures Act, the Dangerous Drugs Act, the Agricultural Produce Grading and Marketing Act, the Indian Standards Institution Certification Marks Act, the Prevention of Food Adulteration Act, etc., which to some extent protected the interests of the consumers. However, a need was felt to pass the Consumer Protection Act 1986 as the procedure of availing remedy under all the mentioned laws was very expensive, time-consuming, and was full of complexities. The Consumer Protection Act 1986 was enacted to provide for better protection of the consumer's interest and for making provision for establishment of consumer protection councils and other authorities for the settlement of consumer disputes, etc. This welfare legislation was well received as a boon by Indian consumers, and the working of the consumer dispute redressal agencies has served the purpose to a considerable extent under the said Act. To provide a speedier remedy over ordinary civil courts, the 1986 Act included a fixed period of time for disposal of consumer disputes. However, it was found that the cases were rarely decided within the period given in the Act. The process in the consumer forums established under the Act was intended to be summary in nature, which does not include any intricacies as involved in a civil court and free of complexities of ordinary civil courts. However, these forums have ended up to become civil courts full of complexities when forums have started pressing for voluminous evidence and arguments, primarily due to the presence of lawyers defending the companies, which force the consumers or complainant to hire lawyers for their cases. In some cases, forums referred the parties to mediation under the provisions of Civil Procedure Code 1908 CPC. However, such cases were very less in number. Besides, there were several shortcomings noticed while administering the various provisions of the said Act. Consumer markets for goods and services also have undergone drastic transformation since the enactment of the Consumer Protection Act in 1986. The modern marketplace contains a plethora of products and services. The emergence of global supply chains, rise in international trade, and the rapid development of e-commerce have led to new delivery systems for goods and services and have provided new options and opportunities for consumers. Equally, this has rendered consumers vulnerable to new forms of unfair trade and unethical business practices. Misleading advertisements, telemarketing, multi-level marketing, direct selling, and e-commerce pose new challenges to consumer protection, requiring appropriate and swift executive interventions to prevent consumer detriment. Therefore, it became inevitable to amend the Act to address the myriad and constantly emerging vulnerabilities of the consumers. In view of all these, it was deemed expedient to repeal the extant law and enact a new law, namely the Consumer Protection Act 2019, which was eventually notified on 20th July 2020. The provisions of the new Consumer Protection Act, the 2019 Act, will have an impact of revolutionizing the Indian justice delivery system in the consumer cases. Now let's discuss the provisions of the consumer legislation by focusing on the new features of Consumer Protection Act 2019. The case laws under the Consumer Protection Act 1986 are still applicable and will be discussed wherever needed. The Consumer Protection Act 2019 is really comprehensive and added various new features in comparison to the erstwhile regime, that is the Consumer Protection Act 1986. As all the features cannot be analyzed in this unit, only the main provisions are covered with special focus on newly added provisions. Let us discuss the new act now while focusing on the main topics. Number 1. Consumer authorities under the act. Number 2. Who can file a case? Definition of consumer. Number 3. Process of filing complaint and online complaint. Number 4. Mediation under the Consumer Protection Act 2019. Number 5. E-commerce issues and challenges. Number 6. Product liability under the Consumer Protection Act 2019. Number 7. Central Consumer Protection Authority. And number 8. Offences and penalties. Consumer authorities under the Act. The Consumer Protection Act 2019 or the 2019 Act provides for 4 types of entities or authorities, which are: Number 1. Consumer Protection Councils from sections 3 to 9. This was also there in the old Act. Number 2. Central Consumer Protection Authority from sections 10 to 27 for protection of rights of common consumers and to deal with misleading advertisements and unfair trade practices. Number 3. Consumer Disputes Redressal Commissions from section 28 to 73. And number 4. Mediation Cells from section 74 to 81. 3-tier system of consumer agencies or Consumer Disputes Redressal Commissions. For adjudication of consumer disputes, there are consumer authorities established at district, state, and center level. These authorities or forums provide an alternative remedy and have not taken away the jurisdiction of the civil courts. The consumer forums have been vested with certain powers of a civil court for adjudication of disputes. Some additional powers for ordering search and seizure have also been conferred. The commissions have the powers of a judicial magistrate of first class for the trial of offences of non-compliance of their orders, which may extend to 3 years. All these powers are vested with all the commissions irrespective of their hierarchy. District level. Just like civil courts, the consumer agencies are established at 3 tiers or levels, that is district, state, and national level. First tier is at district level, that is District Consumer Disputes Redressal Commission or DCDRC. There is one DCDRC for every district in a state. DCDRC consists of president and at least 2 members. The number of members in a DCDRC can go up to 10 members. President in DCDRC can be a person who is or has been a district judge or a person who is qualified to be a district judge, whereas a member in DCDRC can be a person who is not less than 35 years of age and has a bachelor's degree and 15 years of relevant experience. DCDRC must have at least 1 female member. DCDRC can hear a complaint when the quorum consists of president and at least 1 member. DCDRC has 2 jurisdictions, original and review. Under original jurisdiction, it has pecuniary jurisdiction up to ₹1 crore, which means such complaints in which the amount paid for the goods and services is less than rupees 1 crore can be filed before the DCDRC. This provision is different from the Act of 1986, under which the jurisdiction was related to the cases below 20 lakhs. Increasing the jurisdiction is beneficial for consumers who had to travel to state capitals for filing their cases before the State Commission in cases of more than 20 lakhs. DCDRC has territorial jurisdiction over a place where the opposite party resides or carries on its business or has a branch office, or a place where any of the opposite parties reside or carry on business or have a branch office, or a place where the cause of action has arisen, or a place where the complainant resides or personally works for gain. The last clause, that is the complainant's place, has been added by the 2019 Act, which makes it really convenient to access justice at his own city. The DCDRC has also been conferred review jurisdiction, under which it can now review its own orders on the ground of an error apparent on the face of the record. State level. At the state level, the State Consumer Disputes Redressal Commission, or SCDRC, has been established. There is one SCDRC for every state. Some states like Maharashtra have multiple branches in one state. SCDRC consists of one president and not less than 4 members. President of SCDRC can be a person who is or has been a judge of a high court. Members can be persons not less than 40 years of age and are or have been presiding officers of a court or tribunal. Only for 50% of members, or have a bachelor's degree and 20 years of experience in the relevant fields. SCDRC shall have at least one female member. SCDRC has 4 types of judications: original, appellate, revision and review. Under original jurisdiction, it has pecuniary jurisdiction between rupees 1 crore to 10 crores, which means such complaints in which the amount paid for the goods and services is between rupees 1 crore to 10 crores can be filed before the SCDRC. Just like DCDRC, pecuniary jurisdiction of SCDRC has been increased under 2019 Act. Earlier, SCDRC could entertain cases whose value was between 20 lakhs to 1 crore. Increasing jurisdiction is beneficial for consumers who had to travel to state capitals for filing their cases before the State Commission in case of more than 20 lakhs. SCDRC has territorial jurisdiction over the territory of the whole state, that is, all cases of the state may be filed before SCDRC subject to pecuniary value of goods or services. The SCDRC also has the power to entertain appeals from orders of all DCDRCs of the state in which SCDRC is situated. Just like the DCDRC, the SCDRC has also been conferred the review jurisdiction under the 2019 Act. SCDRC also has the power of revision of orders of DCDRCs on limited grounds of error of jurisdiction. SCDRC may also transfer cases from one DCDRC to another DCDRC but within the state. Such transfer orders can be passed on the grounds like where any person in the quorum has any conflict of interest or where multiple cases are pending against an entity in various DCDRCs under the state. National level. At the apex or national level is the National Consumer Disputes Redressal Commission, or NCDRC. There is one NCDRC in the country situated in the national capital, that is New Delhi. NCDRC consists of one president and not less than 4 members. President of NCDRC can be a person who is or has been a judge of the Supreme Court, or has been a Chief Justice of any High Court, or has held the post of member or judicial member for a period of 3 years, or has an experience of 25 years in relevant fields. The members of NCDRC can be persons who are or have been a judge of a high court, or are or have been district judges or additional district judges for a period of 10 years, or have bachelor's degree and 25 years of experience in the relevant fields. Just like the SCDRC, the NCDRC also has 4 types of judications: original, appellate, revision, and review. Under original jurisdiction, it has pecuniary jurisdiction over complaints in which the amount paid for the goods and services is more than 10 crores. The pecuniary jurisdiction of NCDRC has been increased, which earlier was Rs 1 crore and above. Increasing jurisdiction would reduce the pressure on NCDRC, as most cases would be filed before DCDRCs and SCDRCs. The NCDRC has the power to entertain appeals from orders of all SCDRCs. Just like the DCDRC and SCDRC, the NCDRC also has power to review its orders. NCDRC also has power of revision of orders of SCDRCs on limited grounds of error of jurisdiction. NCDRC may have circuit benches in different states. NCDRC also has the power to transfer complaints pending before one DCDRC of one state to DCDRC of another state, or before one SCDRC to another SCDRC under Section 62. NCDRC also has administrative control over all the SCDRCs. Under the Act of 2019, a second appeal on substantial questions of law may be filed before NCDRC when first appeal was heard by the SCDRC. Process of complaint. Section 2, Clause 5 of the 2019 Act defines complainant as number 1, a consumer, or number 2, any voluntary consumer association registered under any law for the time being in force. Number 3, the central government or any state government, or number 4, the Central Consumer Protection Authority or CCPA, or number 5, one or more consumers where there are numerous consumers having the same interest, or number 6, in case of death of a consumer, his legal heir or legal representative, or number 7, in case of a consumer being a minor, his parent or legal guardian. Definition of consumer. Consumer means any person who buys any goods or hires services for a consideration and includes any user of such goods with the approval of buyer. But if goods are bought or services are hired for resale or for any commercial purpose, the case falls outside the Act. It has also been made clear that if a person used the goods bought exclusively for the purpose of earning his livelihood by means of self-employment, he or she is still a consumer and may avail the remedy under the Act. The new Act also includes online transactions through electronic means or by teleshopping or direct selling or multi-level marketing under it. Section 2, Clause 6 contains the definition of complaint, which means any allegation in writing made by a complainant for obtaining any relief provided by or under this Act that, number 1, an unfair contract or unfair trade practice or a restrictive trade practice has been adopted by any trader or service provider. Number 2, the goods bought by him or agreed to be bought by him suffer from one or more defects. Number 3. The services hired or availed of or agreed to be hired or availed of by him suffer from any deficiency. Number 4. A trader or a service provider, as the case may be, has charged for the goods or for the services mentioned in the complaint a price in excess of the price fixed by or under any law for the time being in force, or displayed on the goods or any package containing such goods, or displayed on the price list exhibited by him by or under any law for the time being in force or agreed between the parties. Number 5. The goods which are hazardous to life and safety when used are being offered for sale to the public in contravention of standards relating to safety of such goods as required to be complied with by or under any law for the time being in force, or where the trader knows that the goods so offered are unsafe to the public. Number 6. The services which are hazardous or likely to be hazardous to life and safety of the public when used are being offered by a person who provides any service and who knows it to be injurious to life and safety. And number 7. A claim for product liability action lies against the product manufacturer, product seller, or product service provider, as the case may be. As noted so far, unfair contract has also been included in definition of complaint. Filing of complaints. Complaint containing the relevant facts and with supporting documents need to be filed before the Commission of competent jurisdiction in writing. The new 2012 Act provides for online complaints. Complaints can be filed online on edaakhil.nic.in. The system of online complaints is being streamlined throughout the country. However, currently not all commissions have this option. There is a fee prescribed for filing complaints under rules, but there is no fee payable if the value of goods and services paid as consideration amount is less than rupees 5 lakhs. Procedure to be followed at the time of and after the complaint. There must be a written complaint filed by the complainant along with relevant evidence like receipts, etc. After filing the complaint, there is an admission hearing, and if admitted, a notice is directed to be issued to the opposite party. If the admissibility of the complaint is not decided within 21 days, the complaint will be deemed to be admitted. The opposite party needs to file its reply within 45 days, and the said 45 days cannot be extended by the Commission. The reply is then followed by a rejoinder and evidence. Thereafter, final arguments are heard, and if felt necessary, the Commission can seek an expert opinion in that matter, and even testing of goods can be ordered by the Commission. Limitation for filing complaint. The period within which a complaint is required to be filed before the Commission is 2 years from the date on which the cause of action has arisen. However, a complaint may be entertained after the said period if the complainant satisfies the Commission that he had sufficient cause for not filing the complaint within such period, and if such a complaint is entertained by the Commission, then reasons for condoning such delay need to be recorded. Reliefs that can be granted and execution of orders. The reliefs that can be passed by the consumer forums are: number 1. Removal of defects or deficiencies in the services. Number 2. Replacement of the goods. Number 3. Refund of the price paid. Number 4. Award of compensation for the loss or injury suffered, in this case may also award punitive damages. Number 5. Discontinue and not to repeat unfair trade practice or restrictive trade practice. Number 6. To withdraw hazardous goods from being offered for sale. Number 7. To cease manufacture of hazardous goods and desist from offering services which are hazardous in nature. Number 8. If the loss or injury has been suffered by a large number of consumers who are not identifiable conveniently, to pay such sum not less than 5% of the value of such defective goods or services provided, which shall be determined by the forum. Number 9. To issue corrective advertisement to neutralize the effect of misleading advertisement. Number 10. To cease and desist from issuing any misleading advertisement. And number 11. To provide adequate cause to parties. As noticed so far, some new types of orders may be passed by consumer forums under the 2019 Act, which will improve effectiveness of the Act, particularly in the area of misleading advertisements, the order against erring company or individual to issue a corrective advertisement in case of misleading advertisement to neutralize the effect at their cost. It will prove effective to curb the menace of misleading advertisement. Powers of the Central Consumer Protection Authority. A landmark feature of the 2019 Act is the provision for establishment of a new authority, that is Central Consumer Protection Authority, for protecting, promoting and enforcing rights of consumers as a class and for regulating matters relating to violation of rights of consumers, unfair trade practices and false or misleading advertisements which are prejudicial to the interest of public. The authority has been established in the year 2020 with its office in the capital of India and has started its activities of consumer welfare. It has its own investigation wing which can investigate instances of violations of consumer rights. For the purpose of filing any complaint, consumers can directly approach the central authority or any of its appointed officers for this purpose. Complaint can also be filed before district magistrate. The CCPA can also refer matters for investigation to other regulators such as SEBI. Under the Act, the CCPA has the power to inquire or cause an inquiry to be made into a matter of violation of consumer rights or unfair trade practices suo motu, or on receiving a complaint or on being asked by the central government. It can also file complaints before appropriate forums to enforce rights of consumers. CCPA is listed under the Act as a complainant. In matters relating to consumer rights, the CCPA can intervene in any pending case before any forums or review the prevailing safeguards and recommend changes. The authority can recommend to the government the adoption of international covenants to protect the rights of consumers. The CCPA also has mandate to promote research into consumer rights and raise awareness about consumer rights at the ground level. It can also team up with NGOs and encourage them to work with consumer protection agencies. It can mandate the use of identifiers on goods to protect consumer rights. It can warn consumers against hazardous goods and services by issuing notices and alerts. It can advise the central and state governments and can issue necessary guidelines to prevent unfair trade practices and protect consumer rights. During the course of the investigation, the investigator has the power of search and seizure under the Act. It follows the provisions for search and seizure as given in the Code of Criminal Procedure 1973, where after investigation the CCPA is convinced that consumer rights have been violated, it can order recalling of goods or withdrawal of services, reimbursement of the cost of goods and services, and discontinuation of unfair trade practices. In cases of misleading advertisement, it can also order for any advertisement to be withdrawn or modified. It can also impose a penalty on advertisers which may extend up to 10 lakhs or up to 50 lakhs in case of repeat contravention. This penalty can also be issued on endorsers such as celebrities provided they did not do due diligence before endorsing the product. It can also impose a ban on the endorser from endorsing any product for up to 1 year or up to 3 years in case of a repeat contravention. However, in all these cases, it shall give the other party an opportunity of being heard before imposing penalty. The central government and the state governments have been conferred with the power to make rules under the Act, whereas the NCDRC and CCPA can make regulations under the 2019 Act. Orders passed by the central authority may be challenged in appeal to the National Commission within a period of 30 days from the date of receipt of such order.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.